date. We thought this was going to be on a Thursday. Not sure what's going on.
Yeah, I saw that too, because it looks like y'all are headed to trial. So what they listed for me was it was a motion to compel, but to be heard today, but I don't have a motion to compel. What I have, the last thing I have here, Judge Hahn on June 23rd did set this to universal trial assignment, July 12, 2023 at 1 o'clock.
Correct. We were to have trial on Friday, just this last Friday, but it was set for a half day. There's no way this could get done in a half day. Actually, Commissioner Nelson had started the trial, and so I think this matter needs to be heard before Commissioner Nelson. And it's Ms. Winkle's motion regarding discovery, and then I have a motion that I've talked with counsel about expanding visitation that needs to be heard by Commissioner Nelson.
Okay.
And
so, go ahead.
Probably both of them sooner than later. So.
Okay. So is what I can do for you, I do think that with those requests, right now, the only thing, they did strike the Friday hearing. So I do see in the order that is not happening. The next thing they have for you is the July 12th universal trial assignment. Do you need a Wednesday civil docket to address the discovery issues before trial?
We need a docket and before Commissioner Nelson.
Well, I can't give that to you. So I'm going to have to set you with someone else right now.
And I understand that, Your Honor. I'm thinking maybe July 6th on the Thursday docket, because really going before the civil on the civil docket probably won't work out for the parties because we're also doing the visitation.
Okay.
I know that Commissioner Nelson's not available throughout for an extended period of time. So I think, I'm not sure who's on that July 6th, but maybe Mr. Anagnostou and myself and Ms. Farr, maybe we can get some documents together so that we can kind of give a little background of what's going on in that case for whoever's there on the 6th of July.
And are you asking for the universal trial assignment that date?
No, the universal trial assignment on the, what day is it? The
12th.
12th is fine, but
Okay.
we do need to have a compel and a visit for myself, and then Mr. Anagnostou wants to talk about visitation. I'm thinking if we could do that at 10:30 on July the 6th in front of whichever commissioner. I'm not sure if Your Honor is hearing it.
I will be out of the country, lucky me, so it will not be me, but can we put them to 10:30 on July 6th? I don't think we have a specific individual assigned to that just yet, but let's go ahead and do that. Let's strike today and move the discovery and visitation issue to July 6th. And I can reach out to court admin to let you folks know who gets assigned to that if you need to direct bench copies to them ahead of time.
That'd be great.
Okay.
And that sounds good, Your Honor. And I just asked that Mr. Anagnostou, if you just look at his chat, I'll explain a couple of things, and that would be great. Thank you, Your Honor.
Perfect. Okay, thank you. So we'll strike, move you over to July 6th, and we'll keep your July 12th trial assignment. And we have Mr. SU here. Anything else on that first?
Yes, correct, Your Honor.
Okay. Good morning.
Good morning.
Let me just, my computer's going a little slow, so let me open up the digital file. All right. So the last notes I have on this case, and I believe, is Ms. Farr also on this case as court visitor?
Yes, Your Honor.
Okay, great. Nice to see you. Good morning.
Good morning.
So my notes from June 13 are that the court did extend the immediate emergency minor guardianship. They set it to today at 10:30. The only note I have is that it's set for a review hearing. So I'll let the parties fill me in on what they're wanting to accomplish today.
Yes, Your Honor. Aaron Winkle's appearing on behalf of the child, Damian Waldo. My client is 17 years old. He will most likely age out of a minor guardianship before we even see a trial. My client has submitted a declaration. He is happy where he's at. You'll see, I'm not sure if Your Honor has read the declaration. It is a much better place for him in his opinion. He's going to school. There is no violence. He's very happy. Dad does have a significant history of violence, criminal history with drugs. The mother, unfortunately, is deceased. My client would ask that we enter an emergency minor guardianship order. So I believe Commissioner Nelson was using the immediate order, but what needs to occur procedurally is the immediate order should really be for that first 5 days extended to a term of 14. Then the emergency order should be based on a show cause hearing, which I believe we're on right now today. And then that should be set for 60 days to allow the parties to file a minor or to go to set a trial. So I'd ask Your Honor to enter an emergency minor guardianship order for a period of 60 days with a review. We could do review at 30 days. I will state to Your Honor that speaking to the offices of child support, Division of Child Support, the emergency minor guardianship is not something Cowlitz County is looking at right now for child support purposes. So I'm not sure we need to address that at all. What I've been informed is that in Cowlitz County, we will only look at the actual permanent minor guardianship because there's too much change in that meantime. So I would ask that child support be reserved at this point and that we enter the emergency order so that we can get, if there's not a petition for minor guardianship entered, my client will be submitting one. And then we'll go ahead and set a trial and hear it on that. But that's what my client requested this time. Thank you.
Okay, thank you. And then Mr. SU, any response?
Sure. Yeah, we agree with the with counsel that there shouldn't be any child support. My client is providing car insurance, car maintenance, cell phone use. He's provided a key to Damien and was allowed to come and go at his house if he wishes. I don't think he has. My client is disputing all of the allegations of assault. There may be some history of that in the past, but for the last 3 years, my client has been following his religious beliefs and being able to have a good relationship with his son. And has already signed off on his son being able to go into the Army after he turns 18 or graduates high school. So my client is contesting the allegation. He doesn't believe that those happened, and he has witnesses for that. So if there's going to be a trial, we'd be open to that and willing to go to trial if necessary to keep this from going any further.
Is your client objecting to a 60-day emergency minor guardianship as proposed by Ms. Winkles and her client?
He would be objecting to that because he's disputing the allegations. So if an evidentiary hearing on that issue, we'd be glad to appear for that and take care of that, get that taken care of.
So help me understand what your request is, because I think I stayed on the record. I'm getting up to speed on these cases, and I know you all have been here for quite some time with these cases. What we have right now is the immediate minor guardianship. So what is your request as to what the court is doing today?
I think the court can continue the order as is, but I think the court can also set an evidentiary hearing on emergency guardianship. So because my client is contesting that, he has the right to a hearing and present witnesses and evidence in order for the court to make a factual finding and determination.
Thank you for your position. I appreciate it. And I'm looking here, help me out. Someone probably knows way faster than I will find it. When does this minor turn 18?
April next year, Your Honor.
Oh, next year. Okay.
And Your Honor, if I might, this is the legislation here is really, really confusing, and I think it's confusing to everybody. I've been speaking with other counties, including some of the bigger ones, to try to figure out what procedurally we do. The evidentiary hearing, I think that Mr. Esau is talking about, I've not found that in other counties. I found that it's a show cause hearing so we do the immediate and you have really service and the hearing's supposed to turn around in 5 days. Likely that's never going to happen, but we give it a shot, we put it on. That's continued to the immediate for a period of 14 days. We then come in on a show cause hearing on the emergency where the attorneys argue. I guess if there's a motion for testimony, we do that, but otherwise the attorneys argue based on the pleadings. That gives you 60 days, and at that point you set a trial to be heard on the minor. If you're just on the emergency and no minor's been filed, then you only get that 60 days, and then the child's immediately returned back to the parent unless somebody has filed a minor. That is what I found in other counties. We have not been doing that in this county. There has not been, to be honest with you, a set framework here, but I'm not sure if Mr. Esau wants to do a show cause. I don't mind continuing this if that would be appropriate, but if we're going to hear testimony, my reaction would be then I just file the petition for the minor and we set it for a trial, because really it would be the same amount of evidence twice, but it would be costing the court or the county twice as much if we have two different hearings. Okay.
And Ms. Farr, I did also receive your documents by way of bench copies, so I really appreciate that. And I have had a chance to review it. Input from you on.
Yes, Your Honor. And so the emergency guardianship is entered for 60 days and can be renewed for one additional period of 60 days. And that's the point where we're at right now, is we should be entering the emergency guardianship, and the emergency guardianship is put in place under 11-130-225 when there is a risk of substantial harm that can come to the child. And in this case, there is a long history of domestic violence against the child by the father. And I also submitted with my report copies of police reports showing that not only has the father assaulted the child, but the father has tried to engage the child into fighting himself. So we have some very concerning issues here for domestic violence. And I believe that it would be appropriate to put the emergency guardianship in place. The child is safe where he's at. He's being cared for where he's at. The minor petition has already been filed. It just hasn't been served because the father lives in a locked building and the petitioner hasn't been able to get him served. I've been in contact with Mr. Esau to see if we can get acceptance of service through him. So the emergency guardianship should be put in place while we go forward on the regular minor petition.
Can I speak?
And can you identify yourself, sir? I don't see a name.
Yeah, I'm the father, Chris Waldo.
So
and,
just a second, sir. Hold on. Mr. SU, do you want a chance to have a breakout room with your client, or would you like the court to hear what he has to say without that?
Thank you. I think I know what he's going to say because we talked last night.
Okay.
And certainly is not going to incriminate himself, I'm sure, and is going to dispute the allegation. So, and if the court wishes to hear that now, then that would be fine with me.
Okay. Okay, Mr. Waldo,
Yes.
I do understand what is at stake here. I am going to give you a little leeway to give a statement to the court before I make a decision on this case. I would ask, especially since you are represented, keep it brief. Relevant to the issuance of an emergency guardianship today for a period of 60 days. I think that's the request on the table. And then I would also just remind you, you do have a Fifth Amendment right to remain silent. If you do say something that relates to criminal charges or criminal investigation, it could potentially be used against you. And that's why typically we only hear from attorneys once you're represented, but go ahead.
Okay, so my son has came over multiple times after these guys have called on me and tried to paint me out to be some monster. He has came over, he has talked to me, we've hung out before. And this is multiple times after the fact, all this has gone down. My son has came over. We have talked. He even told me Happy Father's Day on Father's Day. He does have a key to the place. He does ask for money. From time to time, I give him money. My mom gives him money. My wife gives him money. I pay for his car. Anything he needs, he knows he got it. My son is safe. If he wasn't safe, he'd never come around. He would never want to come into my home. He'd never want to be present in front of me. My son knows what's going on, and so do I. And that's all I have to say right now, this moment.
Mr. Waldo, I appreciate you being here. I appreciate obviously the steps that you're taking and the work that you're taking. The relationship between a parent and child is very important to both the parent and the child, but especially to the child. So I do appreciate that. What I am proposing to do today, I'm not the normal commissioner that hears this docket, but I have gone to training on minor guardianship dockets, especially with the new law changes. I have reviewed the statutes before today. I do agree with Ms. Winkles and Ms. Farr that at this time, the court should enter a emergency minor guardianship for up to 60 days. We'll set a review date 30 days out. I just want to make sure, and I appreciate the parties indicating the practice, I guess, locally with regard to not addressing child support yet through the emergency guardianship. That was something that I was not previously aware of, wasn't quite certain what we would do with that. So I'll leave child support to be reserved. The question I have for the parties is typically in these dockets, would Commissioner Nelson prepare that order himself and file it, or is that something the parties prepare and want to present to me? I'm fine either way. I just don't know how he typically did it.
Your Honor, if I may. So when the child is represented and the child is over the age of 12, normally I prepare those orders unless the petitioner is represented by counsel. In this case, Mr. Fasuda, hopefully I said that right, is not represented. So in this case, it would normally be myself, and I would then forward the order to everybody involved as a proposed. They can review, make objections, and then if everybody signs, wonderful. If not, then I would set a presentation on your honor's docket and give everybody notice of the same.
Okay, perfect. That will be very helpful to me. I note, and then also if the parties could let me know, I know the immediate guardianship ends today. It appears to me anyway. So is that an order that we need to get signed today before I leave?
Probably not, but I will try to get it to your honor before today. I'll try to forward it around. Sometimes it takes a little while, but I don't think there should be an issue. There hasn't been an issue yet, and we've had a little bit of lag time in the past.
Okay, that sounds good to me. I will be here most of the day, at least into early afternoon, so I can get that signed if it does come in today. I will also be here tomorrow all day, so I'm happy to sign it then as well.
All right,
Is there anything else you need from the court before preparing that order from any of the parties?
I think, Your Honor, just so the child's almost 18, I would just ask that visitation with dad be at the child's discretion. Obviously the child doesn't want to, stop having contact with dad completely. I just ask that it be at his discretion with a little bit of oversight from Mr. Sasuda, that if he feels that there is a problem, Mr. Sasuda can essentially stop that and immediately file a motion with the court to have a review.
Since day one, it's been Damien's call. The only thing I ask is that he lets me know before he goes.
Perfect. You all are working really well together on this, so I appreciate that. I think that's a good call, especially given his age. And then when we do have that review date, if there's issues we need to fine tune with visitation, we can do it in 30 days.
Perfect.
Okay, thank you all. I appreciate
Thank you,
it.
Your Honor.
Your Honor, one more
Oh,
thing.
go ahead. Yes, please.
So procedurally, at this point, I would be discharged as the court visitor. My fees would be approved, which I haven't filed yet. And then there would be a new order appointing GAL for the minor petition.
Perfect. And I did see that in your report, so thank you for reminding me.
And I'm happy to prepare the GAL order and forward that to you.
That would be great. I think that all of those requests will be granted. Your fees will terminate your work in the immediate proceeding and then reappoint for the standard. Is that the request?
Yes.
Perfect.
And Your Honor, the same goes for Mr. Esau and I. It's a very strange, complicated system at this point. So
Yes.
we were appointed for the emergency. In part of those documents that I prepare, I'll be preparing reappointment of both of us for the minor.
Okay, great. And Mr. Esau, that is your, I guess, request as well.
Yeah, that would be my request as well. Thank you.
Perfect. We will get that done. I appreciate folks walking me through these procedures.
Serenity Aldridge.
Thank you.
Sorry, I just came onto this yesterday at around 4:30 p.m.
No, sounds good. And then I do also have a notice of appearance on behalf of Brian Fletcher and Tracy Hedrick on this case. Mr. Anagnostou, perfect.
Yeah.
Okay,
I'm on this case. There's two cases pending, the Fletcher's case and the Aldridge's case. We'll probably need counsel to get up to speed on the cases.
yeah, let me pull up real quick. So this is the one I have on my docket today is a party show as well for today.
Correct.
Okay, when I reviewed this yesterday, it looked like there was the court on May 30th had dismissed a party.
Right.
And now you're appearing on behalf of one of those dismissed parties, Mr. Fletcher, is that right?
The party that was dismissed was the father. That was Miles Radcliffe.
Thank you for that clarification.
He was dismissed, and I'm representing the petitioning parties, the Fletchers, I didn't realize Miss Winkles was involved in the cases. She is apparently representing the Aldridges.
That's correct, Your Honor. And again, I just came on last night, so I haven't. I have reviewed, and I do have a couple of procedural questions for everybody, or a statement. The first, it appears that a full minor was issued on April 19th, 2023. In the current case that we're talking about, not in the motion that's going to be heard later. On the current case, we have a full minor, which means the emergency, as part of that original minor guardianship, the emergency should have immediately been dismissed. It appears that it was not dismissed. So procedurally speaking, it needs to be. So on this, the motion to dismiss should be granted. And the emergency minor guardianship should be completely dismissed, and it should be consolidated into this. There is a minor. That does not preclude what's happening, Mr. Anagnostou's motion for next week. But in this specific case that we're here for today, procedurally speaking, there should be a full minor and an emergency going at the same time, unless that emergency was filed after and it was filed before. So I'd ask—
On the other case, you're saying?
I'm saying on the current case before us, this motion to dismiss is actually dismissing, the request is to dismiss Mr. Fletcher's emergency minor guardianship, because it appears there are two orders in effect right now. But the one that takes precedence is obviously the order on the minor guardianship. It came later. So procedurally speaking, the emergency minor guardianship should be dismissed. And then obviously Mr. Anagnostou is going to be heard on July 6th on his motion to change the minor guardianship. But the emergency does need to be dismissed. We have a full minor guardianship in place.
Let me just pull up, and you said that's being heard on the 6th.
Yes, I believe that's when.
Okay, so let me.
So your honor, for some clarification,
Yes.
at the last hearing, what Commissioner Nelson said was that he was dismissing Miles as an interested party, as a party. And then he set this date for Mr. Anagnostou to file a response as to why the emergency guardianship should not be dismissed. Otherwise, it would be dismissed today.
That helps me understand the notes a little bit better, because I did, that's the way I was leaning with interpreting the notes from the last hearing, so I appreciate that clarification. On behalf of Mr. Fletcher, are you objecting to the dismissal of the emergency guardianship?
Yes, I am, and I raised the issue with Commissioner Nelson. There's no motion before the court to dismiss, and counsel is indicating, well, it's automatic. Well, give me a cite to that, because I don't believe that's the case. So I was, my issue is there's nothing before the court with regards to dismissing his emergency guardianship, my client's emergency guardianship. And that's the issue that I have with dismissing it.
I think where the court has concerns is that, and I would love your response, is if there now is a subsequent minor guardianship, as I understand it, and I'll be perfectly honest, I haven't fully reviewed that July 6th case, but I understand that there is now not an emergency guardianship, but an actual minor guardianship in place that is subsequent to this. So I think in effect, this has been dismissed. We just haven't done the paperwork. Am I wrong on that?
What it is in the minor guardianship order has a box that it's ticked if you have an emergency minor guardianship, and it says that this emergency minor guardianship is dismissed. The numbers are consolidated. That's a box that should be ticked if there's an emergency. There was an emergency here, but the box wasn't ticked. That's where we're at.
Okay. And so then in the July 6th case, Ms. Winkles, are you requesting that paperwork be corrected, or are you simply saying, well, since that box didn't get checked, we really just need a dismissal on this one?
Yeah, I would love to correct the paperwork, but I think at this point, since it's already there, we just need an order stating that the emergency minor guardianship is dismissed, that the case numbers are consolidated, that the clerk should consolidate them. That way, when we come back on July 6th, it's all one big case. It's not these two separate cases running.
And I am inclined to make that bench. And Ms. Farr, do you, again, having been involved in these cases, do you have any objection or issue with court issuing a bench order to that effect, dismissing this emergency minor guardianship and consolidating into the 13308?
No, Your Honor. So in the report that I filed in the 078 case recommended that case be dismissed because the petition for the on the standard petition was being approved and the full order was being put in place. And that's Commissioner Nelson was going to dismiss that day, the last hearing. And that's when Mr. Anagnostou objected. And so he gave him until today to file his reasons for the objection, or it would be dismissed today. And actually under section 15 of the minor of the findings, it says to the clerk, terminate any linked emergency guardianship cases, including under 234007808. So it was in the findings.
Okay. That is helpful too. I am going to, just for sake of clarification, since it sounds like maybe some of the paperwork did state dismissal, maybe some didn't, I'll issue a bench order based on our discussions today that does formally dismiss this emergency minor guardianship. We'll consolidate it into the 13308.
I represent Monique Barnes, the mother.
Okay. All right. And I do see in this case, I did receive a declaration affidavit since the last time you folks were in front of Commissioner Nelson of Gail Levitt. Is Gail Levitt on Zoom as well?
What's up,
All right. If I'm going to start muting people, if you're not muting yourselves.
So Miss Levitt is here, but she is muted.
Okay, I'm going to start muting some people. Ms. Levitt, if you can hear the board, I'm asking you to unmute. Okay.
Good morning.
If you're logged in with the name Brian please mute. I'm trying to get to his name to mute him. Here we go. Okay. All right. So my notes show this is on for a review hearing. It looks like the last order I have is dated May 30th, where Commissioner Nelson addressed visitation. I have a declaration affidavit in front of me requesting that visitation cease, is what I understand. Ms. Levitt, is that correct?
Yes. Yes.
Okay.
I would ask that the visits continue.
Who's speaking right now?
This is Gary Lewis.
Okay. Is there a position on behalf of Monique Barnes?
Yes, Your Honor. It's my understanding that my client is getting residential time of visitation. And I was looking for my notes on that. And she just wanted to see if there was some way we could expand that to potentially go to overnights. She's getting day visits, is what I recall. Yeah, she's getting 2 hours Saturdays from 9 to 4. And she believes that they're going great and would like to see an expansion of residential time.
And I'm just looking at the original order here real quick. So I guess, Ms. Levitt, this appears to be your motion to terminate visitation. Are you applying that request to both parties, both parents, or just one?
Well, for right now, I just really need to get him back in this whole visitation thing. We have had a terrible month. He doesn't understand. He comes home a complete disaster area. They don't pick him up on time. They don't bring him home on time. And then it takes me 3 days at least to get him where he's okay. I've got him in counseling. This poor little boy has been so messed up. And I am working my butt off to try to fix all of this. I've got him into counseling. I've had an IEP done. Took him to the dentist. He had 14 caps done on his teeth. He has not been taken care of the way that he should be. So what I'm suggesting is give me a 30-day no contact order with either of them. Let me see how far I can progress for this little boy.
And then what?
Hold on. I will ask you to respond, sir, when I'm ready for you. This is her turn to speak. Don't worry, I will come to you. Go ahead.
Okay, so these visits are not doing him any good. I realize his parents love him. I hate doing this. This is not what I want to do at all. But it is my job to watch out for his well-being. And this is not helping him. Not helping at all. We finally had a good day at school after 3 months. And he got to see his parents on a Monday. And he was kicked out of WeCare daycare on Tuesday. He was throwing chairs at teachers. He just is having a really hard time understanding. You know, he loves his parents. I get that. They love him, but they're not capable of taking care of him. They're living in a shed with an extension cord. I am not going to let my grandson sleep in a shed with an extension cord. That's just not safe.
Is he doing overnights with them, or?
No. Well, one time, and they promised me he'd be sleeping in Grandpa's trailer, and he did not sleep in Grandpa's trailer. He slept in the shed. Well, how many fires have we had recently? And people die from extension cords.
Is there, ma'am, would you be in agreement with any modification of visitation? Because it looks like the order signed May 30th, so just about 30 days ago,
Right.
Allowed specific visitation times, but then put in a clause or at other times as agreed to by the parties.
Well, because they were saying that they were going to get jobs and, you know, this and that. And would I work with that? Absolutely, I would.
Mm-hmm.
But neither of them have made any progress on getting their lives together. So.
And is the minor currently in counseling, or that's something that you're thinking of starting?
Yes, we go to counseling every Monday morning at 9
Okay.
at Core Health.
Oh, hold on. We might have lost a participant. Hold on. We lost an attorney for Ms. Barnes. Let's wait and have him jump in here in just a minute. And Ms. Day, I know you were previously on this case. You've concluded your work in this matter, correct?
I was appointed only initially as the court visitor, not as the guardian ad litem. So yes, I have concluded as a court visitor, but based on the motion that was filed and the information that I have, it probably would make sense to have a guardian ad litem appointed, whether that was me or somebody else. There does seem to be quite a few issues going on.
I appreciate that input. Thank you. We weren't sure if we noticed right when you fell off. I did have the other party stop talking as soon as I realized it. Can you tell me kind of the last thing you heard?
The Miss Levitt, the party who has custody, had just finished up, and you were turning it over to Gary Lewis to talk.
Okay, thank you. So Mr. Lewis, let's turn to you. And then I'll also just add briefly, while we were waiting to log back on, I asked Ms. Day, I saw that she had previously been a court visitor on this file. I asked if she was still involved, and she said no, because she had been a court visitor, but a recommendation she made was perhaps to appoint a GAL given the issues going on right now.
Right.
So that happened, and that's all that's happened while you were logged off. Okay, Mr. Lewis, go ahead.
I signed paperwork for my mom to have him. I would like to cease that paperwork since this is since she's wanting to go this route with visitations being ceased. My son misses us tremendously. So what's that going to do if 30 days? So then what? We need our visitations with our son, whether we go to a park. I mean, no, absolutely not. That should not happen at all. Whether she makes progress with him or not. I mean, so my brother had 21 cavities, okay? 21 cavities under my mom's supervision when I was growing up. So what is that? I mean, so there you go. Whatever. I understand. I brought my son over there for him to be looked over for my mom. But like that was in the understanding that I would get visits, but this is not for her to cease visits.
Okay. Anything else you want the court to know, sir?
I am currently looking for work. So, I mean, I'm trying to better my life.
Okay.
But that doesn't, just because I'm down and out right now, doesn't mean I shouldn't be able to see my son and that he shouldn't be able to see me.
Understood. And then on behalf of Ms. Barnes, what is the, is there any response to the petitioner's request?
Yes, Your Honor. I mean, I would just confirm Mr. Lewis's comments. My client has indicated, I thought the visits were going good. It's kind of surprising from Ms. Levitt that they are not. And, you know, my client and the father have constitutional rights to the custody and visitation. And Ms. Levitt has, you know, taken this on, and she's got to understand that if, you know, if at all possible, the child needs to be reunified back with the parents. And her just unilaterally wanting to cease visitation is not, you know, if she doesn't like the job that she's taken on, which is providing basically temporary help until the parents are able to have full custody returned to them, then she shouldn't have taken on that job. But that's the job. She is, you know, the statute is designed to promote parents if they are willing and able to care for their child. And my clients are working on that. And willing and able doesn't mean that she gets to unilaterally say, well, you're not going to see him for a month or so because I don't like how the visits are going. She's got to promote that relationship.
Thank you. So here's going to be my ruling, two-part. First, I do very much agree that at this point we will appoint a GAL and set a review hearing just to kind of wade through this visitation issue specifically in a little more detail. Ms. Day, are you open to that appointment?
I'm not currently on the list, Your Honor, but I would continue in this case if that was what you ordered.
Okay. Is there any objection from the parties to appointing Ms. Day?
There's none from Ms. Barnes.
Mr. Lewis?
No, it's fine.
Okay, and Ms. Levitt?
Yes, I like Tina. She's very good at what she does.
Okay, so you're not objecting?
No.
Okay. And then what I'll do, we'll start talking about a review date based on timing in just a minute. I did read the material, Ms. Levitt. I appreciate you providing that to the court. I read your declaration. I read the diary that you attached to it. I do understand counsel's argument, however, in that, you know, this is a very difficult role. I feel for you. I understand that this is very difficult. I think that anytime a child is going to go through this type of proceeding, probably when they get back from visitation with their parents, there is going to be a bit of acting out. I think that's very, very common. I would note that, Commissioner Nelson did just put the visitation order into place less than 30 days ago. I think we do need to give it some time for this kiddo. So I'm not going to make changes to visitation right now. I will revisit that issue upon receipt of GAL input, because certainly they will have more insight into the parties and the kiddo than I do sitting here without, access to talking to, especially the minor child and the parents. So I do think balancing the constitutional right these parents have, but also understanding that a emergency minor guardianship has been put into place. I think the restrictions on visitation right now are appropriate. I do, ma'am, understand your concerns about overnight visits. And I think that my oral ruling is going to be that I do not want the child to spend overnights with the parents. The current order states that any times outside of those Saturday and Wednesday visits have to be agreed to by parties. So I don't think I need to issue a new order. But ma'am, I would just tell you, you have the court's support to not agree to overnight visits. I don't think right now that's in the child's best interest. Okay. So and again, I'll ask, especially counsel and Ms. Day, typically would Mr. Nelson go ahead and fill out the order appointing GAL in a situation like this?
Yes, generally that's the case.
Okay, I will get that. I'll get that filled out and filed. Oh, go ahead.
Your Honor, I would actually like to have you appoint someone else other than Miss Day. I think her and my mom I think she might be a little biased because she knows my mom. So I would like you to appoint somebody else.
Okay, well, I've already issued my ruling. We're going to stick with Ms. Day. It sounds like your objection is just based on your mom saying that she likes Ms. Day. I don't find that that's good cause to change the GAL I've already appointed.
Okay.
So I'm going to sign that order. Sir, I will just mention, since you are unrepresented, you did bring up wanting to terminate this guardianship altogether. I'm not going to rule on that because it's not before me except on oral discussion from you, but certainly I wanted to acknowledge it and let you know if that is a motion you want to make, you can bring that motion in front of this court and have it set on for a later date, and then we could discuss that topic.
Okay. Thank
you. Anything else from the parties on this matter?
Yes, Your Honor.
Okay.
So just briefly, as everybody's talking about a motion from Ms. Levitt, I have no idea what anybody's talking about. I apparently was not served with a motion. And I'm wondering, part of the problem is the only documents I have is an emergency guardianship, and there's been no main, I call them the main guardianship or overall guardianship action that's been filed, I believe.
The last, what we are working off of is the order on emergency minor guardianship petition.
Right.
And then there was the order, the bench order for visitation signed on May 31st.
Right.
That's all I have.
Okay, that's all I have too. Okay, so there isn't a motion. I thought we were talking about something that had been filed, other than what I have.
He's talking about the declaration.
Yeah, there wasn't a formal motion. It was a review for visits, and Ms. Levitt had filed stuff with the court, and I didn't realize that you were not served, Mr. Anagnostou. I will fax you over a copy of that just so you have it.
Okay.
And it was just a history of how the visits had gone for the last 30 days and her request to address them.
Got it.
And yeah, that's an excellent point. I did not realize you were not served with that declaration affidavit either regarding visitation. So had I changed visitation, I probably would say you didn't receive proper notice and I would reschedule this. But since I'm not approving her request, I don't think you've been prejudiced by not receiving that today. Is that okay with you? Do you have any objection to that?
No, I have no objection to that. That's
okay.
Particularly why I brought it up was because there hadn't been a change, but I was just wondering what had been filed.
Yeah, perfect. I appreciate you bringing that up. And then that does bring up a point. We have the order on the emergency minor guardianship. And the review date for that was, the first review date for that was today.
Right.
What are the parties wanting to set? We're now going to have a GAL with some input. What is the next date that the parties want to review this matter?
3-4 weeks out. Give Ms. Day an opportunity.
I think that gives me plenty of time at least to address any ongoing visitation issues and hopefully meet with the parents. I've had no contact with Mr. Lewis during the course of this matter, and very limited contact with Ms. Barnes.
Okay. So would Tuesday, the 25th docket, the 10:30 docket work for the parties?
Yeah, that's fine.
Could we do the first, Your Honor? I'm out of town that week.
And then we've got the order of, I think, May 30, setting the emergency minor guardianship. Is there something we need to do today to extend that through August 1st?
I would think you would need another order that extended it through that, and then Ms. Levitt will have to decide if she's going to continue and then potentially file for a full guardianship, but that the emergency should extend through that hearing.
So you got 60 days from May 30th, so June 30th, July, yeah.
That's what I'm thinking, is that we do need an extension through that hearing date. Is that something that the parties, it looks like we only have one counsel on this case, that you would like the court to prepare and file?
That's usually how Commissioner Nelson handles it.
Okay.
He prepares an order extending the emergency guardianship to the hearing. You can do that. You can actually extend it a full 60 days for one, so 2 full 60-day periods. But he usually just extends it to the hearing to decide if there's going to be, if it's going to go beyond that.
Yeah, and I think that's would be my proposal for the parties, is that we extend this to August 1st. I'm certainly happy to prepare that order. Ms. Levitt, let me check in with you. Are you willing to stay on as the emergency guardian?
Oh, absolutely.
Through August 1st, okay. My own.
And Your Honor, can I just ask this? I mean, this.
Go ahead.
They don't even have a house. They have nowhere for this little boy to live. So I don't understand why we're even having all of this. You know what I mean?
Well, I think I can sort of answer that for you. Right now, we're in an emergency minor guardianship place. And in this type of place, as counsel noted, reunification with the parents, if it is feasible, is very much something the court looks at. I think you've heard a few people mention perhaps you needing to file for a full guardianship.
I've got the paperwork.
Yeah, I'm certainly not here to give legal advice.
Right.
Be overstepping my role, but you have heard people mention that. So at this point in the stage that we're in and the stage this case is in, the court is walking a very tightrope and a balancing act of the parents' interest, what's best for the minor child. And we certainly appreciate your willingness to continue in this role and support all of the parties. So the court does thank you for that.
Okay, I do have a request because I have to take Tuesdays off. So it costs me like $150 once a month now. Could we be possibly the first on your case on August 1st?
I can't promise that, depending on other things that come up, but when you log on August 1st, if you want to shoot a little chat message to the court as a reminder that you have to, log off early for work, please do that, and we will take your case as quickly as we can. So on this case, I will get 2 orders signed and filed, one appointing Tina Day, and the second extending the emergency minor guardianship, keeping Ms. Levitt as emergency guardian. Anything else we need to do on this matter today?
No, I don't believe so, Your Honor.
Okay, priest present. All right, thank you all for your input.
Yes, I'm here.
Okay, great. Thanks for being here. I have Ms. Holder present. Thank you. And then without jumping into my notes, are you representing Melissa Howard or Joel Showden?
Melissa Howard.
Okay. And then do we have Mr. Showdoin present? Doesn't look like it. Okay.
And I don't recognize all the names. I assume none of them are Melissa Howard.
Do we have Melissa Howard on the line? Doesn't look like it. Okay. How are the parties wanting to proceed on this? The notes I have that state that this is on for a review hearing and perhaps discussion of whether an extension is needed.
And there's an order that needs to be entered. Counsel has sent the order to me for my signature. My client has objected to the guardianship, but I don't have any communication with her. I've tried to reach her. But that order could be entered. I think it's what the court ruled. It's just that because she's objected, I can't sign off on it.
Right, understood. Ms. Holder, what is your request of the court?
Our request is that Mr. Priest be guardian of his grandson Odin. We are not and have not been able to contact the father or the alleged father in this case. We're not even 100% sure if it's the father. We are just understanding from statements that Ms. Howard has made to Mr. DePriest that Mr. Showden is the father. One of the impediments that we've come across is getting a hold of Odin's birth certificate so we can see if Mr. Shoughton has been listed as the father. It is also our understanding that once this order is signed off on and issued, Mr. Priest can get a hold of that, can get a hold of the birth certificate, so then we can be sure that Mr. Shoughton should be left on this matter. And if that is not the case, we would still be pursuing Mr. Priest being guardian of Odin, as Ms. Howard is not very available. From our understanding, she still is not in a position to be a mother.
I'm just triple checking something here. There was, if my email would pull up, the judicial assistant had messaged me, and I want to see if it's about this. Thanks for your patience, everyone. We were having some technical difficulties. I wanted to make sure I wasn't missing a message. So the message applies to some parties in the last case we're going to hear. So not this case. So Ms. Holder, I think that your request was that the court approve an order that I think Ms. Howard is objecting to at this point, but isn't present today.
That's correct.
And then are we doing an extension in that order?
Yes, Your Honor, for as long as the court will allow.
Okay. Mr. Anagnosto, any input on over your objection because of your client's request? Assuming the court is signing that order, what extension date? It expires July 8 right now.
So, and this is an emergency. So you go out another 60 days. The statute allows that.
Is that agreeable to the parties?
Yes, Your Honor.
Okay. Do you want to go ahead and put that date in the order before you submit to the court, or do you want me to add that date?
If you will interlineate it and then sign it, I think that would be more convenient for everyone.
I will absolutely do that. And then that's something, will you be able to submit that order to the court today?
Yes, Your Honor.
Okay. Anything else we need to do on this matter?
Yes, I have a question, Your Honor.
Yes, go ahead, Mr. DePriest.
I have been trying to get Odin registered for kindergarten, but I can't because I do not have a birth certificate. I can't get a copy of his birth certificate because I have no paperwork from the court saying I have custody of him. So they won't issue me a birth certificate. If this goes out another 60 days, it'll be time for school to start. So
my understanding, and counsels can correct me if I'm wrong, but my understanding is this order will in fact allow you to get that birth certificate. And it's
will I get paperwork?
absolutely, you can. Are you located here in Cowlitz County?
Yeah, I'm in Longview.
Yeah, swing by the Cowlitz County Courthouse anytime and you can get copies of the emergency minor guardianship orders in this case.
At the clerk's office?
Yep.
Okay.
And Your Honor, I would just ask to include the guardian ad litem fees. I think they've been included in the order. I just want to make sure that that's done. And then I think that relieves me at this point, unless at some later point a guardian ad litem is appointed.
Okay, and I did see that motion and affidavit declaration. Those will be approved. And Ms. Holder, are those part of the order you'll submit to the court?
Yes, Your Honor.
Okay, great. The court will approve those. And then yes, we will, you are relieved from this case at this time. Do you need a formal order from me to that effect?
No, Your Honor, I don't think so.
Okay. Okay, anything else on this matter?
Yeah, I have just one more question. Why is this getting extended? Because Melissa has not showed up for any of the hearings, has not made any contact with me since before Mother's Day. It just seems to me that she's obviously disinterested in what's happening in this case. She's not contacting her attorney. She did not respond to the guardian ad litem interview for any of this. The only time she made an objection was at the very first hearing, and then nobody's heard from her. Her family has not even heard from her in over 2 months.
And are you, sir, are you self-represented or are you represented by Ms. Holder?
I represent Mr. DePriest.
Okay. So
and that was going to be some of my questioning. I'm sorry, Mr. DePriest, I didn't get to that sooner. With this being extended, I understand that we are extending it to the length that the statute allows at this time. If we are unable to serve Mr. Shoughton, we have tried on numerous attempts to serve him. As far as we know, he's dust in the wind at this point. The last known address we had for him was a homeless encampment that we did try to serve him at. But also, Miss Melissa Howard has been unresponsive to this point beyond her first objection. At what point would the court allow us to proceed with a more permanent guardianship due to her lack of follow through with her objection?
Yeah, and has there been a petition for the full guardianship already filed? I don't have that in front of me.
We can file that immediately, Your Honor. We were just waiting until we could at least get some traction for something, but we wanted an answer before we did that as to the service issue, because we did not want to make a full petition and then still have the service issue be in way.
Yeah, so I'm gonna walk by. I don't want to give a ton of legal advice here. What I would say is let's take the first step. The court will receive and we'll set an initial hearing date on the full petition. And then likely my inclination would be, and it may not be me hearing it if it's in front of me, my inclination would be to issue an order allowing service by publication, and then we could move forward.
Thank you, Your Honor. Mr. DePriest, I'm sorry, did I answer your question, Mr. DePriest?
Yeah, that helps. Thanks.
Okay. So in this case, it doesn't sound like there's an order I need to prepare on this one. I'll wait to receive the order from Ms. Holder and I will get that signed for the parties. And it sounds like that takes care of what we need to do on this case, except set a review date. Did we already do that?
We had a set review date, I believe, and correct me if I'm wrong, Mr. Agnostiu, it was on July 8th.
We do not have a review date for you folks. So let's set a review date. We're going to extend this for 60 days. Let's set a review date about halfway through at 30 days. And at that time, if a full petition has been filed, then we can consolidate and move forward that way.
Your Honor, if we filed a full petition, and would we be able to be heard on that full petition at that review date?
I believe.
Well, that would depend on numerous things, but
Yeah.
being one of them.
Yeah, I don't know if I can give you a concrete answer on that, depending obviously on the service issues and all of those sorts of things, but we could, if you file the full petition and we get it on the same minor guardianship docket, that would be preferable so that we'd have both. And before consolidation, we'd have both cases together on the same docket.
And my understanding is the procedure is on a full guardianship. It has to go to the universal trial setting docket to get a date.
Is that what they do? Do you know? I'm just asking the clerk.
Sure. Right.
Yes, that does go through our trial assignment calendar, which is on Wednesdays.
Correct.
Wednesdays. Yeah. Okay. So let's set a review date for this case, 30 days out or thereabouts. I know summer vacations may get in the way. Did you say does or doesn't?
It does, Your Honor.
Okay. And Mr. DePriest, August 1st at 10:30?
That's fine.
Okay. So let's set a review date for August 1. 10:30, and I can add that to the order you're circulating, Ms. Holder, as well, if needed.
Thank you, Your Honor.
Okay, anything else on this matter?
No,
That
Your Honor.
sounds like, okay, thank you all for your patience and time. I appreciate it. And I do see, and Ms. Day, you are on this case, correct?
Yes, I am.
Okay, thank you. And I do have Catherine Martin. I have Chase, is it Shoup?
Shop.
Shop.
No, is it shop 32?
It says Shop 32 on your screen.
That's me, Your Honor. Sorry.
Okay. Nope,
I didn't, that's me, Michelle
No
Lieber.
And then I have a Brian left in the courtroom. Sir, can you unmute and tell me who you are? I think he might be from a prior case, so we're just going to proceed forward. So this is the case that when I logged off and went upstairs to the judicial assistants, this is a case where the court received an email early this morning from Mr. Lee, who now I believe represents you, Ms. Martin.
Yes, he does.
And he let me know that unfortunately, due to some calendaring issues, he has a conflict and cannot participate today. He had another court call him in for hearings and he will not be available for this case today.
Okay.
So he is asking for a continuance to July 6th or July 11th. The last order extending emergency minor guardianship. It looks to me like it only extended through today. So I guess, and Ms. Martin, this puts you in somewhat of a difficult position because you are represented. So typically I would not be communicating to you without counsel present, but I am going to ask the parties that are present whether there's any objection given the scheduling issue with Mr. Lee, that I find good cause to extend the immediate minor guardianship to July 6th, at which time we would continue this matter.
Unfortunately, Your Honor, I'm starting classes on the 5th of next month, and my classes all start at 9 a.m. Monday through Thursday.
Okay. So I don't have flexibility to accommodate that because we do minor guardianships Tuesdays and Thursdays at 10:30. So I can offer you a Tuesday or a Thursday, but it's always going to be between 10:30 and noon. What, do you have classes that get done by like 11 o'clock or?
I do have one class on Thursdays that do end by at least 11.
Okay. What if we then pick,
I can check my schedule really quick. I have a screenshot of it on my other phone.
I understand. And then let me just check in with the parties. Was there any objection from the other parties on this?
No objection, Your Honor.
Yeah, I have no objection as long as the order carries through whatever that next date is.
Yeah, and that would certainly be my intention to go through that, our next hearing date. So Mr. Lee had proposed the 6th, which is a Thursday, or the 11th, which is a Tuesday.
If I may speak, Your Honor.
Say that again.
If I may speak, I have my class schedule pulled up.
Okay.
So I do have one class on Tuesday and Thursday going from 9 to about 10:30, and it does take me about an hour to get home.
Okay.
Unfortunately, due to the fact I take the bus.
Okay. Do you have a phone with video capabilities that you could maybe stay at the school and take the hearing?
Yes, as long as they have, if they are able to, if they have like Wi-Fi, yes. The phone I have Zoom on does not have cellular data, unfortunately.
Okay. So here's my proposal. Do parties have a preference, Ms. Day, a preference on July 6th or July 11th?
I would prefer July 6th. I'm not available on the 11th. Unfortunately, I have a medical appointment.
Absolutely. So let's go ahead. Let's schedule this for July 6th at 10:30. And then Ms. Martin, what I would just say, and I will fill out that order and get it filed through July 6th at 10:30. It will mirror the terms of the current emergency minor guardianship order with no changes. And then Ms. Martin, I just recommend you reach out to your lawyer, Mr. Lee, this week and just let him know about your class difficulties and scheduling issues. And he might have a different scenario or solution for you. For now, I would just say, try to connect to the Wi-Fi at the school and do it from there. I think the upside is you are represented by Mr. Lee, so and he can also appear on your behalf. So just work with him. Certainly the clerk's notes will indicate that we talked about your scheduling issues. So if you log on a little bit late, we will know why.
I appreciate that. Thank you so much, Your Honor.
Yeah. Anything else the parties, I know we can't do much without your counsel present, but anything else the parties need to address today before July 6th?
No, Your Honor.
No, Your Honor.
Okay. All right. Well, thank you. You're all free to log off. Thanks for your patience and time.
Thank you.
Thank you. Have a good day, Your Honor.
Thank you. You too.
Commissioner, can you stay on for just a second?
Yes, I can.